Manieri, nataka nikupeleke katika mahakama ya Milimani ambapo kesi ya wale jamaa wanne wa Mlolongo ambao walitekwa nyara na hawakuwa wanabainika wako wapi. Ni katika mahakama hiyo ambapo walitakiwa inspekta mkuu ama inspekta jenerali wa polisi Douglas Kanja kufika pale, na vile vile mkuu wa DCI Mohamed Amin walitakiwa kufika katika mahakama, lakini kwa mara nyingine tena wamekufeli kufika mbele ya jaji. Je, kuna nini ambacho kinaendelea mahakamani? Tusikilize kwa sasa hivi.
Against him or her. That is the essence of the rules of natural justice, which all legal systems applaud. Paragraph 19. My Lord, the Court of Appeal confirmed in this holding that that is the purpose of service. And the rules of natural justice are now codified in Article 50 of our Constitution. Are we together, my Lord?
Yeah. I do know. I'm just confirming what you have told me.
All right. My Lord, the Court of Appeal then goes on to say, where therefore judgment is entered against a party who has not been served and hence not been heard, such judgment will be set aside ex debito justitia. Ex debito justitia, my Lord, loosely translated, means as a debt to justice. My Lord, I have been at pains to persuade you this morning that A, service was not effected. In paragraph 11 of both the supporting affidavits, the applicant's last confirmed and used email addresses are set out. In paragraph 11 of the affidavits in support of the application.
Last used to where?
I beg your pardon?
Last used to where?
Last used by themselves.
Where?
I beg your pardon?
Okay. That is, your application sets out the last email used.
Yes.
By your clients.
Yes.
Where?
It is used by themselves. I have said that. And I have also said, my Lord, that the process server.
You see, I don't know where I did. The rule ordinarily was applied towards achieving a certain purpose, that is service. All right? That came about during the period we all know. And I always reiterated that it did not take away the primary rule. That's an amendment. The primary rule of fiscal service remains. Right?
Correct.
So, the import of that rule is that ordinarily the petitioner differently.
The party serving.
The parties, not both parties, were in communication. That's the assumption of the rule. Otherwise, how else would they be communicating, and how else would one know the email, last email of the other? Parties must have been in communication before the cause of action arose. And therefore you are supposed to use the last known email, just like the last known address when you are serving to the registered mail, isn't it?
Correct, man.
You use the last known address that you use last communicated between the parties. So in this case, that's why I'm asking the question. They have listed the email address, communicated between who and who.
My Lord,
Otherwise, if it is their last known address, just like that, I recorded.
My Lord, my answer to that question is that
Let me just get it.
It's for them to say. Paragraph 11, in both affidavits in support of the application, the averment as to the last or the email address is put.
So here is the first respondent, sir?
The first respondent. And my lord, perhaps before I answer your question,
Can you record your question? Yes.
well, my response to that question is that it is correct, as your lordship has said, that the purpose of service is to personally make known to the other side that either the court has made an order or proceedings have begun. My response to that question, my lord, is that it is the obligation of the party who chooses to serve electronically to then persuade the court that, and that persuasion can only come in the affidavit of service, that the email address used is the defendant's or the respondent's last confirmed and used email address. That is the obligation of the party seeking to serve by email. Yes, that is the text of the law, and that obligation is not placed on the respondent in this instance, but it is placed on the petitioner who elects to serve by way of email. As your lordship has correctly pointed out, there are several modes of service. If my memory serves me right, there is personal service, which is the best. There is substituted service, where we can make an application to court and an advertisement is done. And there is email. There is so many ways to serve. Having elected to serve in this way, then it is the obligation of the petitioners to bring themselves within the four corners of the law, and I submit that they have not. My lord, I wish to state that the Inspector General of Police, the first responder, is a different constitutional is established or is provided for the Inspector General of Police. Yes, yes, is established under separate constitutional articles from the National Police Service. I have seen under separate constitutional articles from the National Police Service. The National Police Service is established, and the Inspector General is established. I have seen an attempt by the petitioners in the replying affidavit that I have perused quickly to state that the email address used was obtained from the National Police Service website. My lord, there is an absurdity in that position. One, the National Police Service is not a party to these proceedings. Secondly, my lord, the National Police Service is present almost everywhere in this country. If service on an officer of the National Police Service would then be deemed to be proper if that was the manner in which the email address was obtained, then untold havoc would be told. As was captured in the Sifuna and Sifuna decision, the email service is envisaged to be personal. And that mode of service or that mode of delivery or of sourcing of email addresses does not achieve personal service. My Lord, the last ground I wish to argue in support of my application is the ground which I hope to persuade you to set aside the ex parte orders you made on the 8th of January this year. My Lord, the orders you made on the 8th of January this year require or are for all intents and purposes habeas corpus orders.
Bila shaka huyo ni wakili Paul Nyamodi akielezea sababu za kwa nini wateja wake wamekosa kufika mahakamani, akielezea barua pepe ile ambayo ilitarajiwa kwamba ujumbe huo wa kwamba alitakiwa kufika mahakamani kwamba ungekuwa unafika kwake. Hilo ndio baadhi ya masuala ambayo yamekuwa yakizungumzwa hapo, lakini Jaji Chacha Mwita akisema kwamba kulikuwa na mazungumzo lazima kati ya mteja na wakili wake, kwa hivyo ni kama anahisi kwamba yale yanayozungumzwa hakuna uhakika wake, lakini tutaweza kubaini kile kitakuwa ni uamuzi wake baada ya kuhakikisha kwamba hawa wawili hawa Mohamed Amin na Douglas Kanja wangefika katika mahakama, na vile vile wanne hao wanaachiliwa iwapo hai ama wakiwa mauti, lakini hadi kufikia sasa hawajaweza kuwasilishwa katika mahakama hiyo ya Milimani. Tarudi kule pia kusikia kinachoendelea. Mwanahabari wetu Fred Kagonye yuko pale kuzidi kufuatilia taarifa hiyo, lakini kwanza tuangazie